Hey, my name is Oren Ross. I'm an estate planning attorney, and today I'm going to talk about who needs a trust. So a lot of people ask me who actually needs a trust. Basically, anybody who wants to avoid probate needs to have a trust. So the people who want to avoid probate are people on their second marriage, because if you're on your second marriage and you pass away, your current spouse can get their will changed at any point and cut your kids out completely. They may not do it intentionally, but they get remarried and get a new will with that new person, and then they pass away and everything goes to that new spouse. Even if you have a will that leaves everything to your kids and you pass away, your spouse can file a year of support motion and take your entire estate. So if you're on your second marriage, you really want to avoid probate, because anytime we go through probate with a second marriage, even if the wills are okay, a lot of people don't get along. Kids from the first marriage don't get along with the kids from the second marriage, or the spouse from the second marriage, or whoever it is. Now, you also want to avoid probate if you have heirs who might not get along, because when we go through probate, we have to have all the heirs sign off on the petition and all the things along the way. So if you have people who might disagree on things, you want to stay out of probate, because everything gets bogged down. We have to have court hearings, and that's where you get a ton of attorney's fees. You also want to avoid probate if you have a problem child. So somebody who might be an alcoholic or have drug issues. Ideally, you want to have a living trust so that not only can they not create any issues during probate, but then we can set up an inheritance trust and control how much they get and when they get it. You can spread an inheritance out over time and have somebody else in charge of it, so they just don't get a bunch of money and blow it all at once. And if you have a problem child, a lot of people will disinherit one of their children and think that that's taking care of everything. But when we have a probate, even if you've disinherited a child, they still have to sign off on the petition to probate. And most of the time, they're not going to. They're going to contest your will because you haven't left them anything, or you've left them $1. If your attorney has told you to leave somebody $1, please don't do that, because that gives them standing to sue, okay? So don't leave them $1. Just completely disinherit them, if nothing else. And then if you have property in more than one state, you really want to avoid probate, because we have to go through probate in each state you have property in. So if you have a house here and then you have a house in Florida, you have to do another probate in Florida called ancillary probate. If you have a house in Tennessee, you got to go do a probate in Tennessee. And that's where your costs really add up, because you have to do a probate here, a probate there, a probate there. You can put all that real estate into a living trust and avoid all of those probates. So a lot of people can benefit from putting their assets in a living trust, because for a few $1,000s you can avoid something that might cost tens of thousands of dollars if you have to go through the probate process.